What if the biggest threat to your estate plan isn't taxes, lawsuits, or bad investments, but what happens inside your own mind? In video one, we looked at two real-world situations where carefully prepared estate plans failed as a result of cognitive decline. In one case, a family member moved into the home, isolated the parent, gained control over finances, and substantial assets were transferred before the successor trustee even realized there was a problem. In the second case, the estate plan required physicians to certify incapacity before authority could transfer. But by the time that became necessary, the spouse suffering cognitive decline was paranoid, refused medical care, and the legal trigger for the plan was never activated. If you have not seen video one in this series, click here. Then in video two, we discussed why this happens so often. Not because the documents were necessarily drafted poorly, but because the legal system often assumes incapacity will be obvious, cooperative, and medically well documented. But dementia rarely behaves that way. If you have not seen video two, click here. Hello, my name is Carla Hartley. I'm the managing partner for Hartley Law Group. We are a law firm licensed to practice in Texas and in California. We primarily focus on family and probate law. In Texas, that's family and estate law. Today, we're going to talk about how to build estate plans that actually function in the real world of cognitive decline. The core problem is this. Most estate plans assume incapacity will be obvious, documented, and cooperative. But in reality, cognitive decline is often gradual, contested, hidden, and actively resisted, which creates a dangerous legal window where control is slipping, but legal authority is not yet transferred. This is where estate plans often collapse. How do we reduce that vulnerability window? How do we create plans that work inside of the reality of cognitive decline instead of inside the fantasy version of cognitive decline? Good planning must do two things. It must transfer authority when needed. It must prevent manipulation during decline. Modern estate planning is no longer just about who inherits assets after death. It's also about protecting control during life. It's also about ensuring that the estate of the spouse enduring cognitive decline will provide for his or her support, and that if there is any predeceasing of the spouse with cognitive decline, that the remainder is preserved for the spouse who ended up as the caretaker. A good plan has to solve two separate problems. First, how do we transfer authority when someone can no longer safely manage their own affairs? Second, how do we prevent manipulation before that transfer happens? Because if you only solve the first problem, you may still lose the estate during the transition period. Our first strategy is an alternative incapacity determination. One of the biggest failure points in modern estate planning is the incapacity trigger itself. Many trusts and powers of attorney require one, sometimes two, physicians to certify incapacity. But what happens if the person refuses medical care? What happens if paranoia develops? What happens if the person is isolated by someone exerting influence over them? At that point, the legal trigger can become impossible to activate without great expense and real judicial intervention. One solution is what some trusts call a disability panel. Instead of relying exclusively on physicians, the trust authorizes a small group of trusted individuals to determine incapacity. That group may include family members, advisors, trusted friends, or medical professionals. This approach removes the single point of failure created by rigid physician-only requirements. And importantly, both Texas and California will generally allow this type of drafting. Are disability panels allowed? Many people assume this kind of structure is not legally permitted because it's not the default asserted in the law. But in most cases it is. Both Texas and California will generally allow clients to define how incapacity will be determined. The difference is how the two states get there. Texas and California have different legal frameworks. In California, Probate Code Section 4121 creates a default rule for springing powers of attorney. The statute assumes incapacity will be determined by physicians or psychologists unless the document provides otherwise. That "unless provided otherwise" language matters. With careful drafting, California estate planning documents can authorize alternative incapacity procedures, including disability panels. Texas is even more explicit. Texas Estate Code Section 751.0021 expressly allows incapacity to be determined however the power of attorney states. And under both Texas and California trust law, trust documents themselves are generally highly customizable because these documents are to be signed while the party has capacity, and they are expressing the will of this party as to the future treatment of their estate. But there is an important practical point here. Even where legally valid, financial institutions may still prefer physician certifications. So drafting matters, but implementation matters too. I want you to look at this slide. If you can take a screenshot of it, do so. This is a comparison of California versus Texas incapacity determinations. And since so many people are moving from California to Texas, I think you need to be aware of the changes in law if you want to make an existing California trust certifiable or enforceable in Texas. You don't have to call us. Call a Texas trust attorney who can walk you through whether or not your existing California trust will survive Texas law. The issue with trust incapacity triggers in California is generally customizable. In Texas is fully customizable. The issue of DPO incapacity trigger. The DPOA is durable power of attorney incapacity trigger. Now, the durable power of attorney is what is often done and should be done with your trust suite. Your will, your trust, your durable power of attorney for medical, your durable power of attorney for financial, and probably a living will. That is often the standard package. So the DPOA is the durable power of attorney. Probate Code 4121 in California defaults to the physician standard unless it is overridden. In Texas, Estates Code 751.0021 is expressly customizable. The issue of a disability panel's viability in California is stronger in trusts than in DPOAs. In Texas, it's fairly strong in both. Is a medical determination required? In California, yes, the default is yes for springing powers of attorney. In Texas, no. Drafting sensitivity. In California, the drafting sensitivity is high. You need to have this appropriately drafted, not something you have just downloaded from LegalZoom if you're trying to escape the cognitive decline issues. That is a trap. A lot of people try to save money on a will and trust suite by doing it as inexpensively as possible. The defaults offered are not what you're looking for if cognitive decline is on the horizon. In Texas, drafting sensitivity is moderate. Texas tends to approach the idea that you have a right to contract and that you have a right to make agreements and to issue orders for how your estate is treated, which should be honored. Institutional resistance risk, which I discussed above. This is higher in California. It is moderate in Texas. It is, again, something to consider. The takeaway is this: traditional incapacity drafting often assumes cooperation. Modern drafting must anticipate resistance. Why traditional medical triggers fail? Patients refuse doctors. They refuse to see doctors. We have records that are locked up. Nobody has a HIPAA authorization. The party gets isolated from the family. The problem is not just legal drafting, it's human behavior. Most traditional plans assume the person who is declining will agree to be evaluated, will cooperate with doctors, and will willingly share medical information. But dementia often produces the opposite behavior: suspicion, paranoia, isolation, refusal of any form of treatment or assessment. Once that begins, the family may strongly suspect incapacity, but has no legal way to prove it absent judicial intervention and expensive adjudication. This undoes the whole reason for the estate plan. This is where many plans fail. One strategy you can use is for HIPAA authorization. The HIPAA privacy rule is set forth at 45 CFR 164.502 and 45 CFR 164.508. One of the biggest hidden obstacles during cognitive decline is HIPAA. Most families do not discover this problem until there's already a crisis. A spouse calls the doctor, an adult child contacts the hospital, and the answer is, we cannot discuss the patient. We cannot discuss the patient's care with you, the patient's wishes with you. We can't talk to you. Under federal privacy law, providers generally cannot release protected medical information without authorization. This means that people trying to determine incapacity may be legally blocked from obtaining the information needed to prove it. This becomes especially dangerous when someone else is isolating the impaired person, because now physicians won't communicate, records can't be obtained, and the incapacity trigger may never be activated. Try HIPAA planning before the decline happens. One practical solution is very simple. Sign HIPAA authorizations early, before there is any sign of decline. For married couples, that may mean making sure each spouse is already authorized to communicate with the other spouse's physicians. For aging parents, it may mean authorizing trusted children ahead of time. Because once cognitive decline progresses, obtaining valid consent is going to become extremely difficult or impossible. Once paranoia and manipulation begins, the person who most needs help may become the least likely to sign anything. Good planning can anticipate that problem early, and that's not something you need an attorney to do for you. Just go to the provider, and each of you update your HIPAAs with the providers. Another very useful tool is baseline cognitive evaluation. While the person is healthy, you establish a record of cognitive functioning. That creates a comparison point later. So if there is a dispute, you are no longer arguing abstract opinions. You have measurable evidence. It does not eliminate conflict, but it can dramatically strengthen incapacity determinations. Yet another strategy, anti-manipulation safeguard tools may include a trust protector, amendment review requirements, notice to beneficiaries, strong no contest clauses. Now let's talk about manipulation itself, because the greatest danger period is often not total incapacity, it's partial decline. When someone still technically has legal authority but is becoming increasingly vulnerable to influence. This is where manipulation thrives, especially in secrecy. That's why modern trusts will often build in friction. For example, we can require notice when amendments occur. We can require copies of major changes to be sent to multiple beneficiaries. We can involve co-trustees instead of just successor trustees. We can require independent review of amendments, because the longer the manipulation remains hidden, the hardest it becomes to stop later. I want to insert something here. This series of preventive measures discussed as part of this strategy would foil so many of the people who interpose themselves into the senior's life, between the senior and the successor trustee, the rest of the family, the loved ones who could be helping, even close friends. And the reason for that is a lot of times we see this person who has interposed themselves just taking the senior who has cognitive decline but is not yet fully incapacitated to a new trust attorney, to draft a new trust, to draft a new will. Often this is done without anyone's knowledge. But if you have these requirements in the prior trust before the decline begins, then if we have to go into court to throw that subsequent trust out, all of these things become evidence we can use to protect your senior, to protect the estate so it continues to be used for them, to ensure that homes don't go into foreclosure, to ensure that homes don't have titles change. There's so much that we need to protect. These are all good suggestions to do it. Again, you don't have to come to us. You need to go to somebody. Some families will also choose professional oversight. I'm a big fan of this. A professional fiduciary can monitor financial activity, identify unusual transactions, create accountability, and act as a neutral buffer between family members. This can be especially important in high-value estates or complicated family dynamics. Sometimes the best protection is simply having someone independent watching the process. Estate planning today is about protecting autonomy during decline, not just the transfer of wealth. For decades, estate planning focused primarily on what happens after death. But today, many of the greatest risks happen long before that, during cognitive decline, where control does not disappear overnight, it erodes, and during that erosion, people can be isolated, manipulated, and financially exploited. The legal system was not originally designed for the realities of modern dementia, but your planning can be. Thoughtful drafting can reduce the vulnerability window. It can make manipulation more difficult, and it can dramatically improve the chances that your plan actually works when it matters most. And if those preventive measures have already failed, if the manipulation has already begun, you should speak with an attorney in your local area immediately. Because sometimes the solution is no longer preventive planning, sometimes the solution becomes litigation. Depending on the evidence, a court may decide that the current trustee or acting family member lacks capacity, was improperly influenced, or is no longer capable of serving as a trustee or DPOA. If you are the properly named successor trustee, the court may be willing to recognize your authority and restore control of the trust administration. There are legal hurdles. These cases become harder and more expensive with delay, which is why the best approach is always early planning before cognitive decline turns into a legal crisis. Because modern estate planning, I have said it before, is no longer just about death. It's about protecting autonomy during decline. It's about ensuring that the estate that your seniors or that you have accumulated during your lifetime is available for you when you need it. My name is Carla Hartley, and I hope this has been helpful to you.